The BBI Court of Appeal case hearing entered day 2 today, with the BBI Secretariat, the IEBC, ODM leader Raila Odinga and President Uhuru Kenyatta seeking to overturn the ruling of the High Court that found the BBI as illegal, null and void. President Kenyatta, through his personal lawyers, Waweru, Gatonye and Kimani, Kiragu, told the Court of Appeal that the president was not served by the BBI petitioners and therefore he was not afforded an opportunity to defend himself.
The president should have responded to the petition in person or through his legal representative. But surprisingly, my lord, their lordships did not ascertain whether the president had been served. And my lord, it is true that the president was never served with the proceedings, despite the fact that he was sued in his private capacity.
Like any other Kenyan, his legal team submitted that the president enjoys rights in the Constitution and he should not have been condemned unheard.
It doesn't matter whether there was evidence or no evidence in relation to the cause of action against the person who has not been served. It is a nullity. I pray that this honorable court, that your lordships do set aside all the orders and all the declarations adverse to His Excellency the President.
No one has pointed you to any provision in the Constitution that bars the President from initiating an amendment to the Constitution through the popular initiative.
An argument, however, arose when the judges took the lawyers to task to explain in what capacity was the president represented by the Attorney General in the High Court. Defending the head of state, his counsel alluded that he was condemned in his personal capacity.
The only issue, senior counsel,
yes,
you're not clarifying to us is that you see Mr. Olochier alleged that the appellant in this case did certain acts in his personal capacity. That is an allegation. There is a Gazette notice which shows perhaps otherwise.
I think it is moot whether he was acting in his official capacity or not. That's settled. That's not before you for determination. But I think, my Lord, Mr. Justice Kiragu is entitled to a straight answer. If it's a question of a dog, in my view, so.
On the other hand, Atiende Omolo, representing ODM party leader Raila Odinga, submitted that the BBI was a popular initiative and was originated and promoted by Junet Mohamed and Waweru, and not President Kenyatta, as declared by the High Court. The IEBC, through former Attorney General Githu Muigai, said the High Court interfered with the independence of the IEBC mandate, which is protected by the Constitution, by directing it on how to execute its mandate. Those in disagreement with the appeal are preparing to argue their case before the 7-judge bench tomorrow on why the appeal should be thrown out.
Article 143(2) of the Constitution confers on the President absolute immunity.
Giverson Minor, K24, Nairobi.